Well, can you see that? Okay, the PowerPoint. Okay.
Perfect. Yeah, champion.
Great stuff. So, so I'm James Betts. I'm a solicitor at OA Mitchell in the Public Law and Human Rights Department, as Kate mentioned. I mainly specialise in special educational needs, so representing parents and young people who are challenging the provision that the local authority are putting in place. I do also undertake social care work and work in the Court of Protection as well, representing people that lack capacity. So the talk today is looking at the legal challenges that have been brought in amongst all of the changes and issues that have been brought up by the pandemic. And we'll be focusing on the cases that have been brought by and on behalf of children. Conscious we've only got an hour, so we're going to focus on the children's cases in this talk. So my colleague Oliver Studdart, who was involved in one of the challenges that I will talk about later, will be joining us later on for the question and answer session. Hopefully, he's got childcare commitments have meant that I'm kind of doing the talk in his place today. But yeah, hopefully he'll join us later. So what we'll look at is kind of what impact COVID-19 has had on the work that we do and the people that we advocate for. We'll be looking at what's changed kind of in terms of on the ground, in terms of the legal changes that have been made, what legal challenges have been brought against those changes, and what potential issues could come up in the future that we need to be aware of and could give ground for further challenge. And we'll be looking at that stuff mainly in the context of education and social care. And we'll also be looking at kind of where things stand in terms of kind of visits to people that may lack capacity and children. We'll also look at judicial review. Judicial review is the main way of challenging policies and decisions that are made by public bodies. So we'll kind of look at the key kind of principles of judicial review that you need to be aware of. We'll kind of go through and summarize everything, and then we should have time for a bit of Q&A at the end. So in terms of COVID-19, obviously it's had a massive impact on everyone. On the way that, for example, I'm doing this talk at home today, but it's impacted all areas of our life. But it has had a particular impact on disabled children and their families. And I was looking at some stats to find some information, and Scope have done a useful report, and the Activity Alliance have also collected some data as well. And I think it's useful to kind of draw kind of attention to the impact that it's had on disabled people. So 28% of disabled people have said that they feel forgotten about during the coronavirus pandemic. Parents of disabled children have reported that worsening emotional and mental health for their children and themselves. Over 2/3 of people report that health and or social care assessments have been delayed during the lockdown. And disabled people increasingly feel that this government isn't supporting them. So let's put some stats there. 45% felt that way in April, but by June that had increased to 60%. And obviously we're in kind of coming up to November now, and I wonder if that figure might have increased further since then. And I think this is quite alarming as well. Less than 1 in 10 parents say that support from local councils and the NHS has stayed the same during the pandemic. So we can take it from that in 90% of cases, support's changed or has been reduced. So it has had whilst it's impacted on everyone, it has had quite a dramatic impact on disabled children and those that care for them. So firstly, I thought it'd be useful to kind of divide things up a bit between education and social care. So we'll look at what's changed in terms of education during the pandemic. So obviously we're all aware that at the beginning of lockdown, schools closed. There was for most people, obviously some children were able to attend, children of key workers and with the HCPs, but there were, in the main, schools were closed. There was then a phased reopening, and as of September now, all schools are now expected to be open, and all children, the government expects all children that can to return to schools. And there has been separate guidance published in relation to how that should happen, and that guidance is there to help schools set out what they need to do. And there's been separate guidance for mainstream schools and for special schools, and there's links there that are put, so when this presentation is shared, you can easily go to that. And I wrote this up a few weeks ago. So I imagine these figures have increased since then, but we commenced in 12th of October, whilst the schools were reopened, 46% of secondary schools and 16% of primary schools had pupils isolated from COVID, and overall attendance was down to 89%. And I imagine all of that it seems as though the virus is on an upward curve at the moment, that those figures might have increased since then. So obviously during the pandemic, other things that happened were people weren't able to sit exams. So there was the question of how grades going to be awarded. And we had this entire palaver about the algorithm and the teacher assessed grades that were eventually used. So we'll look at that. Because the schools were closed, obviously lots of children were being educated at home. So that was an issue. They were still entitled to suitable education. So we'll look at the issues that has brought up. And in terms of the legal changes, one big change was that the Coronavirus Act provided scope for the absolute duty in an education and healthcare plan. So an education and healthcare plan is the document that children with special educational needs have. It's a legal document, and anything in there, the local authority or health, if it's in the health section, are legally obligated to provide. That's a strict legal duty. What the Coronavirus Act did is it allowed the Secretary of State to issue monthly notices to water down that duty from an absolute duty that you must provide this to one that you must use your reasonable endeavours to provide this. So that was a big change. And the Secretary of State was issuing monthly notices in relation to that. At the moment, the last one they issued was in July, so things are back to normal there. And then there was also regulations that altered the timescales in relation to EHCPs. So usually there are strict timescales by which local authorities need to complete EHCP assessments and annual reviews. That was all watered down, and basically the local authorities were given a bit of a get out that if they weren't able to do that because of COVID, then as long as they were doing their best endeavours, then that was fine. And again, at the moment, those changes have ended, and that ceased on the 25th of September. So that's some changes that were made during all of this in terms of education. So all of those things impacted, I would say, probably disproportionately on disabled children. So what was the fight back? How did people fight back against that? Because they did. And there were some key cases that we'll look at. So there was a legal challenge, judicial review challenge against the downgrading of those EHCP duties that we just talked about. There was proposed challenges in relation to the A-level grades and the algorithm. There was challenges in relation to suitable education and the reliance on online learning and making sure people were able to access that. There was the free school meals issue that's cropping up again. There were also changes to school exclusions and the law around that, so we'll look at that. Now, the first five things I've mentioned there are all policy challenges, so challenges brought against a particular policy. I think it's also important to mention that there were still individual challenges being brought during the pandemic. And just because some of the duties were watered down slightly, that hasn't meant that it's not a get out of jail free card for a local authority. And there are still duties owed by them, and people were still able to successfully challenge and get increased provision through that method. So we'll look at all of those things. So this first case, Shaw and ABC and the Secretary of State for Education. This was a challenge brought by a young person with an education and healthcare plan against that watering down of the duties in relation to EHCPs that we talked about. So that changing from an absolute duty to deliver provision to one of best endeavours. And in terms of the context behind that challenge, the Children's Commissioner had said when it was introduced that she had serious concerns that the downgrading of these key duties towards children with special educational needs was disproportionate, and that the SEN system was one that's already under a lot of strain even before COVID. Mitchell were involved in challenges last year about the funding allocated for children with special educational needs, and the Commissioner was worried that these changes could result in or that being stripped back further. So the challenge was brought, it was a judicial review against the Secretary of State, and the main argument was that in making the decision to make these changes, the Secretary of State had failed to consult with people that it should have consulted with. So parents, carers, disabled children, and the organisations that kind of advocate for them. Now, once that claim was issued, the Secretary of State relatively quickly confirmed that we were in July by this point, that there was no intention to issue any further notices beyond July. Now, the proceedings continued, though, as there was still concern that the Act, the Coronavirus Act, still allowed the Secretary of State to say in a few months' time, well, things have changed now and we need to issue another notice, for example, during a second wave. So that case went to a full hearing. The judge found that that decision wasn't unlawful in that case, that it was a decision of Parliament and not irrational, and that they felt that an appropriate level of consultation had taken place. Now, that decision has been appealed, and at the moment, as I understand it, the court is still deciding whether or not to allow that appeal to proceed. Now, I think it's important to note, though, that even though it wasn't successful, one, the Court of Appeal might overturn that decision, but secondly, would that notice have been withdrawn? So the proceedings were issued, and the Secretary of State says, I'm not going to issue any more notices. Would that have happened so quickly were it not for the legal action? And I think it does show that even if not successful, judicial review combined with campaigning can have a big effect. So that was one key case involving children's rights. Now, obviously, there was this whole palaver about the algorithm that was used to allocate A-level grades. Essentially, teachers were assessing people to be working at such a level, and the algorithm was applied, and in a lot of cases was marking them down quite significantly. And if you recall, there was concern that was impacting disproportionately on certain categories of people. So people kind of in maintained schools as opposed to independent schools, for example. So all of this moved quite quickly once the grades were released. But in amongst all of the publicity, there was a pre-action letter proposing grounds for judicial review sent on behalf of the Good Law Project to Ofqual and the Secretary of State for Education, setting out a proposed challenge to the system. And just to give an example, kind of some of these changes that the algorithm were producing were quite stark. So one claimant in this challenge, teachers had assessed them working at as getting 3 Bs, and the algorithm, once that was applied, downgraded that to 3 Es. So that's a massive shift. So that challenge was threatened based on a breach of natural justice, procedural unfairness, because there wasn't a way that students could automatically appeal those decisions, that the scheme was irrational, and that it was a breach of various statutory duties and the Equality Act, and that it was discriminatory. Now, that letter was sent, and within days, the Secretary of State quickly changed their position. The algorithm was withdrawn, and the grades awarded by teachers were to be used instead. And again, as with the last case, that shows that legal action, in this case threatened, I don't think it didn't actually get to proceedings being issued, combined with publicity and campaigning, can result in massive change. So that was a really good result, albeit that some damage had already been done, because some pupils might not have got the place at the university that they had wanted and might have to have gone somewhere else or be waiting another year. So that's the A-levels. Another case was brought in relation to this duty. So Section 19 of the Education Act provides that every child that isn't able to attend school is entitled to a suitable education. Now, that was a duty that wasn't changed by the Coronavirus Act. So every local authority was still under a duty to ensure that the children in that local authority were provided with a suitable education. Now, a challenge was brought, not against the government, but against the London Borough of Southwark, due to concern that this reliance on online learning, so these children are out of school, and a lot of schools were kind of setting work online, and there was concern essentially that not every child would have the access to kind of a laptop or a tablet or adequate broadband to enable them to engage in that. And again, that could disproportionately impact upon certain people, so those that don't have the money to get that equipment. So a challenge was brought against the local authority on behalf of parents whose children attended state schools but didn't have access to that equipment. And again, a letter was sent threatening legal action, and following legal pressure, government committed to investing around 85 million and funding 200,000 laptops to ensure that the most disadvantaged children don't fall behind whilst the schools were closed. So again, another example of proceedings being threatened, a letter of claim being sent, immediately resulting in this really good outcome. Now, this issue is cropping up again because it seems as though the government seems to be backtracking on that. I've read an article just yesterday about schools concerned that they're not getting the laptops that they were promised. So I expect maybe future challenges to be brought against this. But at the time, that was a really good, quick result. We also had free school meals. So if you recall, in the summer, coming up to the summer holidays, there was concern that free school meals weren't going to be extended over the summer holidays. And a challenge was actually brought against that by Sustain and the Good Law Project again. And a pre-action letter was sent at the beginning of June. Now, with a bit of help from Marcus Rashford, now MBE, the government quickly reversed their decision. And again, that was again another result, campaigning combined with legal action, or threatened legal action, government backtrack and reverse their decision. Obviously, that issue is now coming up again, and there could be scope for a similar challenge. The position the government have taken at the moment in relation to that is that they're not extending it because local authorities can provide extra support when needed. So whilst there may be a strategic challenge that could be brought, the people that we work with could also be advised to approach the local authority, who should do a proper social care assessment and provide any extra support that's needed. So that's kind of another example of ways that individually people can still work within the existing framework to get what they need as well. So that was that issue. Quickly, I'll touch upon the school exclusions. I'm conscious that we've got a lot to get through, but essentially at the moment, pre-coronavirus, there are strict timescales for people being able to challenge an exclusion if they're excluded from school. So they can appeal to the governors and then to an independent panel. And those hearings must take place within a certain amount of days. It's usually 15. Now, the coronavirus led the government to introduce regulations that extended that time to 25 school days. Now, that extension only applies if a face-to-face hearing was needed. So if taking place by video, it must still happen within the original time limits. But the regulations basically gave the school the power to decide whether or not to offer a video hearing. So essentially what that meant is that there was a concern the school could insist on a face-to-face hearing and then therefore extend the time frame to 25 days for each review, which if you think of it, someone might need to go to the governors and then the independent panel. That could then create a 50-day window, which is quite a long time to be excluded from school. So Just for Kids law raised concerns with the DFE that was unlawful. They made it clear that they were prepared to take legal action, and that resulted in changes being made. So the DFE confirmed that if families wanted a video hearing, the school can't refuse one, and that schools needed to help parents be provided with the facilities they need to access a video hearing. So again, that was legal action threatened, very quickly, positive change brought about by that. Just to let you know as well, new regulations have been brought in now from the 25th of September, so that 10-day extension no longer applies. Instead, if they can't do it within the normal 15 days, they can only extend it for the shortest period possible. And that's going to be in place until 24th of April next year. And then this is a case of mine. I thought it was useful just to show how even within the changes and the watered down legal framework, you can still get positive results. And I think this is important because sometimes I think people see that the law has changed and they think they can't do anything, but it wasn't a get out of jail free card. So this was to local authorities. So this was a challenge brought against what we said was a failure to provide a suitable education to a child who had an education and healthcare plan, and also the failure to provide the provision that was in this child's education and healthcare plan. So the child was out of school because school was closed, and his EHCP provided for 25 hours a week of individual support. So this was a case where the watering down of that duty to deliver the support was relevant because it used to be an absolute duty and it was now one of reasonable endeavours. So we were instructed because at the time this child was working from home, he had an app, but that app that he was using to do work was the same as for all the other pupils that didn't have special educational needs, and it wasn't differentiated to take into account his particular needs. So because of that, his parents had arranged as an emergency kind of measure to get a private tutor in, and they'd asked the local authority to fund that and hadn't got anywhere. So we were instructed, we sent a letter of challenge setting out that, look, you still have to exercise your reasonable endeavours to provide the provision in the plan. There's no reason that there is a tutor in place right now. Therefore, it's clearly possible to provide this, and we asked the local authority to pick up the funding for that. They did do that, and they provided parents with backdated payments to fund all of the provision that they'd had to self-fund themselves. So that case shows that these changes that have been made, like I said, they're not, I keep saying it, but they're not a get out of jail free card. And it's important to be clear that there are still duties owed by local authorities, even when these changes were in force. And if they come in force again, it'll be the same. So obviously that is a good resolution for our particular client, but I do wonder that that was just one client. And I imagine there might have been lots of parents and children in similar positions who weren't able to bring a challenge, which is quite a sobering thought. So in terms of potential future issues, so we've looked at the cases that were brought last time. If it seems as though we're heading into tighter restrictions, things are likely to crop up. So what might they be? EHCPs, the government could issue a further notice downgrading the duties again. Also with EHCPs, I anticipate there could be a big backlog in terms of annual reviews that haven't yet been completed and EHCP assessments that need to be done. The legal timeframes are back to normal now, so the scope to judicially review any delay in relation to that. There's also the issue of these children have been out of school now for a long time, and they're going to need to catch up for a lot of work that's missed, and how is that going to be done? Now, there has been some extra funding released to help children catch up. So is that going to be used properly? Some children are still out of school. They might have needs that mean they need to shield. Are they getting suitable education? If they have EHCPs, are they getting everything that's in there? There's the issue of suitable transport. So for those that are eligible to receive school transport, that needs to be suitable transport. And what might have been suitable pre the pandemic might not be suitable when you consider the ability to socially distance. And it still needs to be safe. So there could be issues there. We talked about laptops and the fact that the government promised this extra funding, and they seem to have backtracked on that. So if a child doesn't have the ability to access whatever education is taking place at home, then there could be challenges there. There's the question around how are exams going to be dealt with next summer, and that needs to be done fairly. Free school meals, that's coming up again, which we've talked about. Potential school closures again. And I think it's also just important to flag that when there is a dispute in terms of SEN provision, parents are able to bring cases to the SEN tribunal. That's continuing to operate. They've been very good, actually, the SEN tribunal, and they very quickly moved to video hearings, which has actually increased their capacity to hear cases, which is meaning that they're able to get through things and still process cases and make decisions, which is good. So that's education. We'll look at social care now. So in terms of the duties to children, main duties to children in terms of social care flow from Section 17 of the Children Act and Sections 2 of the Chronically Sick and Disabled Persons Act. And essentially, those duties mean that local authorities have to assess children that are in need. That includes disabled children. Once they've done that assessment, they need to then meet the needs that have come up during that assessment, and they should have a plan in place to set out how those needs are to be met. Now, those duties weren't impacted upon by the Coronavirus Act. There were no changes, so local authorities still had to comply with those duties. Now, at the beginning of the talk, we mentioned that 9 out of 10 people said that their support hasn't stayed the same. So a question, I imagine it sounds like if things have changed, that there might have been breaches of this duty. Other changes to children was the adoption and children coronavirus regulations that essentially made a number of changes to various laws that provide safeguarding checks in the adoption process and in relation to the procedures related to children in care. Now that's expired, but has been replaced with new regulations that contain some similar changes. So that was one change, and there was a challenge in relation to that my colleague Oliver is involved in. So we'll look at that. With adult social care, the situation was slightly different. The Coronavirus Act did make changes, and it allowed local authorities to temporarily suspend the duties under the Care Act to meet needs, from one of you have to meet the needs to one of you need to make sure you don't breach someone's human rights. It didn't provide the same level of protection as it would normally. The Act also allowed health bodies scope to delay assessments for continuing care as well. So there were changes in relation to adults, but in terms of the key duties to children, they stayed the same. So I mentioned these regulations here that diluted the safeguards owed to children through the adoption process and owed to looked after children. Now, the Charity Act, Article 39, were involved in bringing a challenge against that dilution of safeguards. And that was a case that my colleague Oliver Studdart, who's going to join us later, was instructed on. So that challenge was brought around the failure to consult with the Children's Commissioner before making those changes. It was also argue to the entire spirit of the primary legislation, which is the Children Act, that basically the entire point of the Children Act, the key principle there, is to safeguard and promote the welfare of children. And it was argued that this dilution of duties, whereby all of these safeguards that were previously set out in law to look after not disabled children, looked after children and children that are going through the adoption process, that removing those safeguards was unlawful. Now, the decision in relation to that case went to a full judicial review hearing, and I've put an outtake from the judgment here. And essentially what the judge was saying is that in anything less than what was considered to be a national crisis, she would have been minded to find that failure to consult with the Children's Commissioner made the decision unlawful. But in this case, the judge basically felt that due to the extreme urgency caused by the pandemic, she was willing to give the government more discretion due to COVID. So in any other time, that decision would have been found to be unlawful. Now, that case was appealed, and the appeal was heard at the beginning of September. So the court felt that there was an arguable appeal there, and we're awaiting judgment on that. So watch that space, and Oliver's joining us later and might be able to update on that. In terms of, I thought this case is a useful one in terms of looking at the importance of kind of family contact and when balanced against the restrictions. So this was a case that concerned a family, a mother and 3 children. All the children were looked after under an interim care order. They were living with grandmother. Now, pre-coronavirus, mother had direct supervised contact with the children. Due to coronavirus, that was replaced with unsupervised telephone contact because the contact centre had closed. Now, when the restrictions were lifted, the mother asked for that contact to be reinstated, the direct contact. Local authority opposed that. They said the children were too young to observe social distancing, and they relied upon government guidance, which said different households were only permitted to come together in open spaces. The guidance then changed to allow social bubbles, and so the mother applied to the family court for an order granting a bubble to be formed between her and the children to allow supervision in a park. Now, that application was dismissed initially by the court, who found that the existing arrangements were reasonable. Mother appealed to the family court, arguing that they kind of looked at the law incorrectly, and that the individual welfare of the children hadn't been the basis of the court's decision. That went to the Court of Appeal, and they confirmed that, yeah, that's right, and that the ordinary principles governing applications for contact with children continue to apply during the pandemic, even though the outcomes may well be affected by some practical difficulties. So that case reinstated that local authorities are under a duty to allow reasonable contact with parents, even during the pandemic. They must promote contact between child and the parents unless it's not reasonably practicable or consistent with the child's welfare. And it's the child's welfare that is the paramount consideration if a case is brought to court. So that's a case that you can refer to if you've got any concerns that children are being unreasonably denied contact with their parents. So that was that case. So in terms of future issues for social care, what might happen? So obviously further restrictions could impact on carers' ability to provide support to disabled children and the families. Will a carer be able to come into the house to support a family? We've got the judgment awaited in the JR brought by Article 39 about those crucial safeguards. We've also got the fact that schools might be closed, and so children could be at home for much longer. The extra strain and kind of that puts on the family, that might result in a requirement for extra social care support to give parents a break or to provide an extra pair of hands and help. How will assessments take place? Social assessments are key, aren't they, in terms of making good decisions about what support a person needs and how are we going to do good assessments during the pandemic. We need to be creative. Social workers need to be creative and do as thorough assessments as they can. Got local authority budgets. Government are putting more and more pressure on local authorities to provide support, free school meals, things like this. So these budgets are being stretched, and they already were. Is that going to make local authorities inclined to look at reducing care packages? If local authorities can't find support, are they going to try and pressure people to accept direct payments? We know that direct payments should be a choice. You shouldn't force someone to provide direct payments, and they're not a way for a local authority who can't find something themselves. They can't just put that on to another person. We need to be aware that any blanket decisions, so blanket policies, so that could be a policy to not allow visits, or it could be a policy to reduce care by a certain amount. Any blanket decisions like that are likely to be unlawful. We could have the issues when children are turning 18, are they getting their adult social care assessments? And obviously all of this is in the context of where it's looking like the restrictions are probably only going to get tighter for the immediate future. So all of these things could crop up. So that's a quick look at social care. Got 20 minutes left, so quickly have a look at what the law is around visits, and then we should have some time for some questions. So the regulations, so these are the same regulations that were being challenged because they contained bits that remove these crucial safeguards. They also confirmed that visits to looked after children during the pandemic should be allowed to take place over the telephone or online, only if face-to-face visits are not possible. So there's still that presumption that a face-to-face visit is better. And if a face-to-face visit isn't possible, children and young people should be told why that's the case and be advised of their right to advocacy or support. Now, the guidance has confirmed that these regulations are intended to be used kind of where just to give flexibility when needed. When, for example, so the reason if you're not going to be offering a face-to-face visit, this needs to be because it's contrary to guidance relating to COVID-19, or if it's not reasonably practicable for a reason, again, relating to an incident or transmission of COVID-19. So there needs to be a good reason why. Now, before deciding to undertake a virtual visit, the nominated officer of the local authority should consider the wishes of the child or young person, the ability, is that child or young person able to engage in a virtual visit due to their age or disability? Is there an established bond between the social worker and the child or young person, and any other factors? So again, all of this is I guess trying to say that if it's safe, then a face-to-face visit is better, essentially. Now, I thought this was useful. This was a letter that was written by the Vice President of the Court of Protection, Mr. Justice Hayden, very recently, just a couple of weeks ago. Now, this related to visits, family visits to care homes, and I think the principles are relevant to work that we do with children as well. And so what prompted this letter was the new tiered system and kind of the restrictions contained within that. And basically what the judge was saying is that even in tier 3, he's looked at these regulations, and in his view, that there's nothing in those regulations that prevents a relative kind of visiting a care home potentially, and he refers to the exception I put there. So he does say that arrangements will have to be tailored to the particular individual and the circumstances within the home, but basically what he's saying here is that the restrictions in themselves aren't enough to rely on to prevent contact with a family member. There needs to be kind of a good reason there. There's nothing in the regulations that automatically prevents that. And I do think there's scope to argue that the same principles apply to visiting children as well. So it's a helpful thing. and I think it's available, should be available online, and we can always forward it on if anyone thinks that it would be useful, because it was a public letter. So, issues to consider in terms of visits. Providers and local authorities should not have blanket policies. There must be flexibility. My grandma's in a care home in Gloucestershire, and I think they do, as a local authority, have issued a policy of no visits. And my family are currently sending a letter about that, because that's a blanket policy. There needs to be kind of flexibility to look at each decision on the individual facts. And the guidance around visits confirms, in terms of advocacy, I thought this was an important point. If you ever kind of have opposition, that guidance confirms that the ongoing provision of advocacy for looked after children is of critical importance, and as such, local authority duties to provide it remain unchanged. We've also got that case of DS that I talked about that emphasised the importance of contact with family. And we've got Justice Hayden's letter as well that we've just talked about. And I also just wanted to flag that my colleague Kirsty and Dr. Oliver Lewis, who's speaking today as well, I think, have put together a really useful guide if a family member is in a position where they're not being allowed to visit somebody in a care home. And again, whilst it's directed at adults, I think a lot of the principles are the same. So I'll put a link there to that in case it's useful. So all of these challenges that I've talked about have been brought by way of judicial review. So very quickly, so we've got time for questions, some kind of a very quick kind of summary of judicial review, because my colleague Oliver Carter is doing a separate session on this later. So that's going to give you more of the detail. But essentially, judicial review, often called JR by lawyers, is a challenge brought to the High Court, where the High Court will then review the lawfulness of a decision made by a public body. So any local authority, any CCG, hospital, they're all going to be public bodies. Now, judicial review needs to be brought within 3 months from the date of the decision, and not just 3 months, but it also needs to be brought as soon as possible. So sometimes you can be within the 3 months, but the judge might still say you're too late. So you need to, if you're thinking about legal action, you need to get advice very quickly. Now, out of those cases I've just mentioned, all of them were judicial review cases. I think only 2 or 3 of them were actually cases that were then issued in court, because so many of them were resolved through pre-action correspondence, which shows kind of the pressure of a judicial review can be really big and often will result in the public body backing down. So we've talked about kind of examples of judicial review being used for individual cases, like my client who wasn't getting the education that he was entitled to, but we've also seen it being brought against kind of government decisions and regulations that were introduced. So you can bring strategic challenges as well. And essentially, to bring a judicial review, you just need to be a person that is potentially going to be impacted upon by whatever decision you're going to challenge. So examples of strategic cases that could be brought, and these are just some that Owen Mitchell have brought within the last kind of couple of years, a failure to consider the impact on disabled individuals when making a decision, or introducing a new policy. If a local authority hasn't kind of done an assessment to look at what impact this might have on disabled children and adults, then that could make it unlawful. Local authority cuts to special educational needs or social care funding, the amount of funding allocated by central government. Owen Mitchell, I think there's a picture there. Owen Mitchell were involved in a challenge against the amount of money set by the Chancellor of the Exchequer for special educational needs. Guidance that's issued by the government or Secretary of State, Department of Education. Again, if there's stuff in there that doesn't seem right, that can potentially be open to challenge. Individual local authority policies, closure of children's centres, contact centres, respite centres, all of these things potentially open to challenge. And also plans, for example, any cuts to short break service that give parents respite, any changes to those can be challenged, and Owen Mitchell have been involved in those types of challenges in the past year or so. So yeah, just think strategically, I guess, here. Judicial review can be really good for individual cases, but you can also use it to challenge kind of government policy and decisions. And as we've seen, you get really good results. So funding options, how would you fund a judicial review and who can bring one? Anyone affected by the policy can fund it. Funding options, children will usually be eligible for legal aid. If legal aid isn't an option, crowdfunding is a way of raising money to bring legal action or to get advice. Provided some links there to crowdfunding campaigns for cases Owen Mitchell have worked on. And I mentioned the crowdfunding. Sometimes the crowdfunding page in of itself can be a very useful campaigning tool. It can get press and put pressure on the public body. Like I said, need to act quickly with judicial review, but it is an option. It can change the law, it can raise awareness, and it can exert a lot of political pressure. It can seem scary to people to bring a judicial review, particularly if you're challenging kind of a government policy or a law. But in actual fact, judicial review, it's mainly legal arguments being done by lawyers. So in terms of, in comparison to, for example, an SEN tribunal, there is most of the work is done by the lawyers. And I've just done a link there, I hope he doesn't mind, to a really good blog post that Steve Roach, who a lot of you might be familiar with, wrote a while back about judicial review and about the process and why it can be a really good remedy, and it's not something that people should be scared of bringing. So do have a read of that. So in summary, I guess, hopefully, we flag some issues that might come up that we need to be aware of. I think just be prepared to challenge them and seek advice if something doesn't seem right. Often if it doesn't seem right, there will be something wrong with it. Also bear in mind that yes, there might be changes to the law that water down duties, but that isn't a get out of jail free card. It doesn't mean things can't be done. Legal aid is available for judicial review. As we've seen from all of those examples, this government does have form for backing down when challenged. We've looked at all of those judicial reviews that were threatened and then quickly resulted in positive change. And yeah, if something feels wrong, it may well be. And seek advice, and the lawyers will be able to advise you on that. And my colleague, Oliver Carter, I think he's got a session at 3:30 today looking at judicial review in more detail. So do attend that if you can. So how we can help, Owen Mitchell, we've been involved in a lot of those judicial review challenges that I've just talked about. We have a legal aid contract for judicial review. We also have a contract to do court protection cases. So for children that are young people over 16, that lack capacity, the court of protection might provide an option. We family law cases that involve deprivation of liberty, we can be involved in. Special educational needs is still in scope. We can do judicial review on those. Tribunal appeals, there's a link there for how to access help for that. We can do work on a private basis for people that aren't eligible for legal aid. And yeah, so do contact us if you do think that there might be an issue. So hopefully we've not run out of time. I think we've still got a bit of time left for questions. I'm not sure if Oliver has joined us yet.
I have, yes.
Hi, Oliver.
Welcome.
Thank you. Sorry, everybody, for my lack of appearance, but I'm here for the Q&A and hopefully won't be interrupted by a small child.
I think we haven't been Zoom bombed yet by children this week. It would make a refreshing change, Oliver. Don't worry about it at all. Okay, so we've had a few questions come through. One, I think you've just kind of touched on there, James, around the financial risks attached to JR with the person being liable. So the question is there any advice about other funding other than legal aid? I know you mentioned crowdfunding, but is it worth just outlining in a bit more detail pros and cons of that financial risk that might put people off?
Do you want me to take this, James? Give your voice.
Yeah, you can do. Yeah, I'll let you do that, Oliver.
So the advantage of legal aid funding is, of course, the lack of cost risk to the individual. And as James said, most children are likely to be eligible and a number of adults. And if legal aid is available, it's always a preferable option because privately funding a judicial review is going to be very expensive. not only in instructing solicitors, which is likely to be upwards of £30,000. If you win, you'll get your costs back, but if you lose, you'll be liable for the other side's costs as well. So crowdfunding is always an option, but that doesn't exempt you from having to pay the other side's costs if you're unsuccessful. It is possible to seek what's called a cost capping order if you're an organisation bringing a challenge, and if you can show that you don't have the funds to be able to pay the other side's costs. So in the Article 39 case that James was referring to, the charity Article 39 crowdfunded for their own costs, or for a proportion of their own costs. We acted on a discounted conditional fee agreement, which meant that they just paid us a low hourly rate for the work that we did, and that was what the crowdfunding paid for. And we sought a cost capping order from the court, which the court granted, which limited their costs, if unsuccessful, to just £5,000. So although there's still a cost risk, it's a much more manageable one. The downside of cost capping orders is that they're only available at the permission stage. So up until the permission stage, you don't know what your cost liability may be. You don't know whether the court is going to award the order. And so there is the risk until you get to that stage that you don't know what the costs might be. I think it's something that we as claimant lawyers are very mindful of, and there's a review of judicial review going on at the moment, and our submissions, which I don't know if they're available online, but certainly we can share them with the attendees today. I can send Kate the link to the letter. Does make the point about accessibility to judicial review, because judicial review is a fantastic remedy, and be able to threaten judicial review can have incredible outcomes, as James has outlined. Often a pre-action letter from a solicitor is all it takes for the other side to back down. But at the moment, only 20% of people in the UK are eligible for legal aid, which essentially means 80% of people aren't able to bring a judicial review, and that is grossly unfair. I fear that the government's review of judicial review is more with a view to restricting where it's available rather than extending it. But that is a point that we have made, and we're not alone in making that point. I know Public Law Project have made that in their very, very good and detailed submissions as well, which are available online.
Thank you. Next question is around a specific family. So that the young person is on a guardianship order and lives with granddad, but she doesn't want to. And she hasn't been able to have any contact with her mum or siblings or grandmother, and even the advocate. She can't cope with remote access, so she's just missing out on contact. Any thoughts on what the advocate can do to challenge that? And I know we're not asking for legal advice, so if you want to make your disclaimer, go for it. But just general thoughts.
We're not childcare lawyers, and if there's a special guardianship order, then it would have been put in place through the family court. So it's not something that we at Owen Mitchell can deal. And I know it is possible to challenge an SGO. You need to be able to show that there's been a significant change of circumstances. I think that COVID is probably justified in arguing that it's a significant change of circumstances, but I think it would be something to get family lawyers involved in.
And I think, can young people also bring challenges in their own right under, is it Part 8 of the Children Act? I've got it in the back of my head. Is that, I'm just thinking, if the young person themselves are unhappy.
Yeah, I mean, it potentially, but I mean, I know you mentioned as a young person with autism, how able she would be able to sort of identify that this is a challenge that she wants to bring.
Okay. Well, I don't know whether she's got autism. Sorry, I think it was just.
I think I'm sorry. I was reading through the lists here, and I think scrolling through the comments. Young autistic girl, I think.
Okay, is she? Right, okay.
But I mean, I think the first port of call will be to try and speak to the guardian, who will no doubt be on the scene, and see if it's something that they'd be prepared to bring back to court. If not, then maybe speak to specialist solicitors to see if it's something that they could assist with. Yeah,
and a bit concerning that the advocate's been stopped from visiting, and kind of that's something I think advocates can push back on and to find out, well, why, and is that reasonable, and the particular set of circumstances that mean the advocate can't visit. I was smiling wryly, James, when you were talking about social workers not visiting. A lot of advocates have been asked by social workers whether they'll do the social work visit.
Okay. I've just seen we've got an update on that question. She does have autism, but is capable of making her own needs. Are you able to just put how old she is in the comments as well? 17. I mean, if she's 17, then yes, it's quite possible that it is something that could be dealt with outside of childcare solicitors. So if it's something you wanted to contact us about and we could talk and give you some ideas directly, I'm happy. I think my contact details were at the beginning. I'm not working today, but I'll be contactable tomorrow if you want to talk about what options you may have in more details and give me some specific individual facts.
Look at that. It's like you two work together a lot. Brilliant. Thanks. Is that okay, Sarah? If well, we can, yeah, get Oliver's email there. And then Simone was asking around guidance that apparently came out last week. I'm sorry, I'm not familiar with it. It promotes remote education for all people, all pupils. Is there? So the question is, can we use this when supporting disabled children to access remote education, especially children on EHCPs?
Definitely, there's something in there that's helpful. To be honest, I don't know if I've actually read that guidance yet. So I'm not sure kind of what the nature of the guidance is, but
well, I'll quickly, I'll just unmute Simone because she's got her hand up. So Simone, do you want to just quickly come in? It's okay if you don't want to. Okay, we'll leave it. Sharon, you've had your hand up for a bit, so I'm just going to pop you up to be able to speak in case you can't ask the question in the chat box. So feel free to go for it if that was the case. I started typing you a question to say if you got your hand up because you can't type a question, but of course that was rather silly in the chat box because you wouldn't be able to respond if the answer was yes. So forgive me.
Well, while you're looking for that, Kate, just in terms of guidance, generally, kind of whomever the guidance is directed at should be following it, unless there's a good reason not to. So, if you think that there's a piece of guidance where there's something that kind of is helpful to you, then I think you're right to kind of raise that. And if whomever you're raising it with, raise it and ask them kind of if you're not able to follow this, can you explain why?
Yeah.
I think I've brought it up just in front of me. It wasn't something that I was familiar with. I mean, it does say that it clearly it applies to special schools as well. And I think, you know, that has to be right. But I think challenges against this will need to be brought on an individual basis, depending on what the policy is, what the support is that's not being provided, what the EHCP says, if there is an EHCP, what the school is or isn't doing. I think foresight is really important. Try and talk to the school. What if there's a closure? What can we do? James mentioned the quality impact assessments. If there were to be a bigger, wider challenge, you could look to see whether the government considered what the impact would be on disabled children. It's quite possible that they didn't, and there may be a challenge against the government here. That's not necessarily going to help an individual who's not receiving education at the moment in time, though.
Yeah. So is this the Coronavirus Act being extended to look at remote education?
No, this is the direction.
Have you got a link there, Oliver? I'm struggling to find it. Just yeah, it might be useful for people.
Yeah, I can email that to you now, Kate. I've got the link to the.
Excellent. We'll circulate that to everyone. So thanks, Simone, for raising that. That's really helpful.
I think it's important as well, just to mention in relation to that ultimately Section 19 of the Education Act still places a duty on local authorities to provide suitable education to children out of schools. That's the primary kind of piece of legislation. And for children within the education and healthcare plan, at the moment, as things stand, they're entitled to receive all of the support that's in their plan. So there are those kind of key legal duties that if someone does have concerns that they're not being provided with suitable education, that allow you to kind of challenge that and provide some teeth. Got you.
Lovely. Well, I can't see any other questions, and we've come just over to our hour. So shall I say thank you so much for that really interesting and helpful session. There's loads in there that I wasn't aware of, and I know from the chat box people are really grateful for you talking about them. So yay, thank you guys, marvellous.
There was one question, sorry Kate, there was one question just on school closure figures, which I can give a little bit more information on if that would assist. It was whether they're higher in the north, and yes they are, unsurprisingly, given what we know about national lockdown. I think the statistics I've seen are that in some areas of the north, Manchester, Liverpool included, secondary schools, around about 40% are affected by closures, not the whole school, but year groups, as opposed to in the south, it's closer to 90% that are open. So it's a significant difference between north and south. And I think especially, well, for all children, but especially those who are going to be sitting exams at the end of this year, there's going to be quite a lot of people in the northern schools who are going to have very strong arguments that they have suffered and they're going to be falling further behind and going to be more disadvantaged as a result. So I think the issues around school exams has certainly not gone away, and will be something that we'll certainly be looking at closely over the next few months.
Thank you.
Thanks.
Right, okay, thanks everyone, and
Thank you.
for our next session. We've got Belinda at 2 o'clock, so get your pens ready because she talks fast. Does Belinda? Get your pens and paper ready. Brilliant. Thanks again, James. Thanks, Oliver. Really appreciate your time today. Brilliant.
Cheers. Bye.
Take care. Bye. Bye, everyone.